SEPs and innovation. It reflected considerable disagreement between, as you can tell, patent holders and implementers. It handled a more general context, but this particular panel of distinguished jurists will shed some light as it reflects to the judiciary. I'm Thane Bauz, IP partner at Bauz IP Law, and just a reminder of the Chatham House rules, which are projected behind me. Our panelists include Judge O'Malley. She's retired from the U.S. Court of Appeals for the Federal Circuit. She's now of counsel for Irell Manella. She's the only U.S. representative on WIPO's Judiciary Advisory Board. That's significant for today's event, given how many folks from WIPO we've had address these topics. She was nominated by Barack Obama and confirmed in 2010, and just recently retired from the Federal Circuit. Also joining us is Judge Bencivengo. She's a district court judge for the Southern District of California. She was nominated to the bench by President Obama in February of 2012, confirmed at that time. She's one of only 3 judges in San Diego who presided over patent cases during the patent pilot program. We also have with us Judge Robart, U.S. District Court Judge for the Western District of Washington. He authored the first opinion setting out FRAND rates for SEPs, and that was Microsoft v. Motorola. Judge Hoffmann's also here with us from Germany. He just gave the luncheon presentation. I won't belabor his bio. All the judges' bios are on the website, www.globalfrand.com, and also on the viewer. So let's start with the first question concerning worldwide FRAND determinations. We know in Huawei v. Samsung, Judge Orrick, U.S. District Court Judge, commented that how is he to determine FRAND rates globally when there's national patents and differences in different markets outside of the U.S. Meantime, we have Unwired Planet v. Huawei, where Justice Burse stated quite the opposite, where there should be a global rate for a global portfolio involving global market participants. So I'd like to just open with the question concerning your thoughts on determining a worldwide FRAND rate. I'll throw that to the panel.
Okay. Well, all right, I'll go first, because I would like to take an opportunity to defend my actually good friend, now Lord Justice Briss. He was not competing to try to do in the Judge Albright kind of way to bring cases to himself. I think he thought that the case was presented and that he had to address it. The reason he ended up setting a global rate was because he believed that that's how the parties would have set it. That, in other words, in that market, they only negotiated on a portfolio-wide basis, and they did it on a global analysis. So he ended up setting it consistent with what he thought was the business practices. And then, if you remember, he did not say you have to use this rate everywhere in the world. He said you have to agree to this rate for purposes of your sales in this country, and if you don't agree to this rate, then you're barred from sales in this country. Now, admittedly, the UK is a big and important market. Also, once you've agreed to that rate, how do you say to somebody else, I'm not going to agree to it somewhere else? And so, as a practical matter, it probably had close to a worldwide effect. But he was trying to sort of stay within his lane as much as he could and apply the principles clearly. So I think that part of the problem is it is the way businesses do their analysis. It's the way they set their rates. And the courts have to look at it from the standpoint of, well, what kind of agreement would there have been? You know, we create a hypothetical world, but it's supposed to reflect the real world.
I have great sympathy for Justice Briss. He was in the same dilemma that I think I originally faced, which was we just didn't have any guideposts of where to go. I don't think that his decision was terribly practical, and I think what happened because of that is that it went up to the equivalent of an appellate court who modified it dramatically. And I had to write down the names of these. I would urge you all to take a look at Nokia versus OnePlus, which has basically kind of set aside Unwired Planet and struck off in a new direction that really deals with the issue that you mentioned, which is what do you do with global rates? If you look what happens next in China, Sharp versus Jiangdong, they basically jump right out and say we have no trouble setting them, and in fact we're encouraging people to come here so that we can do so. The United States, I think, I'm not sure we'll get consensus on this, but I doubt that we're going to get ourselves into a situation where we're going to try and set global rates. And I think there are some very profound implications in that position for intellectual property practice in the United States. And then I'll defer to my German colleague because I don't read German as well as he speaks English. But as I understood the Sissel versus Heise decision, the German courts are now authorized, they have the ability to set a global rate. So you've got 4 very major players in the world intellectual property market who have, as one of the panels was discussing before lunch, we've really walked away from, or at least modified the idea that patents and patent systems are a national situation, which is enshrined in the U.S. Constitution. That, you know, the patents are one of the few things that's mentioned in terms of the law. And I'm not sure that we're not marching on a road to extinction in terms of national patent systems.
So there are 94 district courts in the United States, and we're courts of limited jurisdiction. And I think in integrity and fidelity to my role, as Judge O'Malley said, I'm going to stay in my lane. And so I adjudicate for the parties that are in front of me where I have subject matter jurisdiction. And I'm not sure I am properly ever in a place to adjudicate the rights and the liabilities of people who are not present in my court, or to set a rate that's going to affect property that's not subject to a U.S. patent being applied to it in the United States. And so I'll adjudicate for the people in front of me what they bring properly to me. How that gets applied worldwide might be persuasive, but I don't feel comfortable that it could be determinative, that what other people are doing somewhere else with different manufactured goods that may also be subject to some set of the group of patents that were presented to me are bound by whatever ruling I make in my case. I think that's beyond our jurisdiction.
Well, I think it depends on how the comparables look like. Like you said before, if you have comparables where parties voluntarily agree to have a global rate, then how could it be fair to set up a FRAND that is not global? Mm. I mean, if you say all the others set up, I can agree to global rates, be it differently from region to region or whatever, and then I have to accept a license agreement just because it's concluded in a litigation that only covers one country. That's hard for the SEP holder, because that means I have to sue him in every country, which if constructive negotiations take place, will not be the result. Therefore, I think if you really can see that almost everybody is willing to take a license with a global right, then the one who does that only in a litigation has to accept that as well.
Yeah, just going back to what I was saying about what I think Colin was trying to do is that there's a difference between understanding what's going on in other countries for purposes of assessing what a global rate would look like and having authority to impose something like an injunction on an extraterritorial basis. So I think in the US, we'd certainly have the tools, just like we have experts to teach us all kinds of things, to figure out what a global rate would be, but we wouldn't have the tool to enjoin someone from not using that rate in another country for sales in another country. So it's really, again, the practical effect might be that, but I think that there is that sort of place where we can thread the needle.
And you can still bring it in. I mean, it's evidence. It would be part of the determination of what's reasonable. If they're giving rates and people know what they are in other countries for the same technology and similar manufacture, then that would go into the determination. Because I don't see this as a rate. It's there's not going to be one specific number necessarily that's going to apply to everybody, but a range or something that's in the same ballpark. But in some ways, I'm not quite sure how that's any different than when you just do a reasonable royalty in a regular patent case. And as someone had said earlier, you want transparency. Most people, when they would come in for a settlement conference, they would say, it's not so much about what I pay, I just don't want to pay more than my competitors paying to license this same patent. So I need to know what they're offering. And that's very important discovery in determining when experts are going to talk about a reasonable royalty rate. What is this technology being licensed for amongst everybody else? And whether it's just the competitors in the United States or globally, it's still going to be important evidence to consider.
Okay. Let's turn to injunctive relief, which is another hotly debated, discussed topic. At a high level, the criticism is it's very, very easy to get an injunction in Germany. At the other end of the spectrum, others say it's too hard to get an injunction in the United States, any injunctive relief. They draw dichotomies between eBay and ITC. Both take a while, and does that help holdouts? Versus Germany, which gives access to a quick injunction and perhaps is an abuse of dominant position. So I'll turn that over first. It's a long table setting, but I'll let Judge Hoffmann handle that first.
Well, we have this law, we have this tradition, and it is reasonable to say if you have a patent, you shall get a monopoly. So if you don't have to license because the conditions as laid out in the ECJ judgment, Huawei versus CT, are not fulfilled, then it's obvious that you get an injunction. Because if you are not willing to take a license, for instance, which is mostly the reason why the implementer loses, then why should he be able to proceed infringing the patent? And we don't have, we have now a law that says we have to regard proportionality on the injunction issue, but the hurdle for this is much higher than it is in the United States. And especially if you got FRAND cases where you have usually some kind of FRAND rate by the SEP holders, you can always say, what's the harm? You just take the license that is offered from the SEP holder as it is offered to others. Unless you have a different unless you have a different system, which you don't have in Germany, like eBay versus Merck, it's normal to get an injunction as it is for any other infringement case, and it is the way to enforce your patent.
I have to say that with the last panel, I agreed with everything that Kurt said, and not a lot of what was said otherwise, because I think that the notion that eBay has done away with injunctions in all circumstances is silly, and that it wouldn't ever apply in this circumstance is even more so short-sighted, because if you look at eBay, what the court said is you have to apply the factors. And yes, there are a lot of judges who sort of read that to mean that mostly you're not supposed to give injunctions, but it's not true. And if you look at the statistics, there are a lot of cases in which injunctions are still issued. In this context, I would think that the public interest in preserving the standards field is huge. That we want there to be good standards. We want there to be innovation that uses particular standards, that allows the innovation to move more quickly, as someone said. I mean, we're moving into the next 5G space, and we're going to get to 6G even faster than that, and it's because we've got standards. And I think that the public interest in making sure that that system remains intact would be huge, and would be a big factor that one would consider in applying the eBay tests. So as much as I do not like eBay for a variety of reasons, I don't think it stands completely in the way of injunctions in this space.
My take on that is that injunctions are the patent holder's best friend. And I think that gives you a opportunity to look into how various national systems are based. If I were a patent holder, I would have an eagerness to go to Germany, because I really am going to control the pitched battle. And I have the authority of the court to you, the alleged infringer, that there's not much you can do about it. You're going to get a very reasoned decision, but in the meantime, you're going to be able to accomplish the point of view that you're attempting to persuade. If you come to the United States, I think we're much more interested in setting the appropriate royalty, and under the teachings of eBay, you see fewer injunctions. The wrinkle that I had to deal with was one of the parties in a case, having not done very well in the United States, went to Germany and got an injunction, which significantly interfered with my ability to adjudicate the case in the United States. I did not, and I don't believe anyone would, enjoin a foreign court, because I don't think we have the authority to do that. But I do have that party in front of me, and I can say, you are prohibited, enjoined from enforcing the injunction that you got in Germany. Didn't make me any friends in Germany, but I think to this day it was the proper decision. And right now, with the Chinese courts, who seem to use injunctions fairly regularly, you're running into this tension with, well, what about all the other countries in the world where there are sales taking place? What do we do with your Chinese injunction in Albania? I think that's an unresolved issue at this time.
Well, maybe add two things. First of all, we have no problems if a country does not enforce the judgment of a different country. We do that with the United States judgments as well, if they have punitive damages as a basis, because we say that that is now not our system, that is so much against our ordre public that this kind of judgments cannot be enforced in Germany. That's one thing. The other thing is why you get the reason why you get injunctions in SEP cases in Germany more easily is because we very much take a look precisely on the question whether the implementer is really interested in getting a license. And I mean, I think we could talk about eBay very long, but to say that somebody who is not really interested in getting a license should be able to participate in the business still be able to participate in the business anyhow, that is not really good, that would not be a good structure for business. I mean, if somebody said that the licensee has no obligations under the FRAND obligation. Formally, that might be right if you take the construction of contractual basis. In Germany, we have another basis. We have the antitrust law basis. But the point is, you should really be willing to take a license, because otherwise you take yourself out of the game.
Of course, I think that I don't know how an injunction can get granted until the determination of essentiality is made. I mean, it's one thing to say that once you're in the system, you agree to a FRAND rate, and you're essentially effectively assuming that the patents that you are practicing are valid for purposes of that standard.
Yes.
But what if they're not really essential? And given the numbers that we heard earlier today, that 50% of them are not, or likely not, I don't think that in the US you could ever get an injunction without passing that threshold.
That's right, but as far as I consider the German judgments about SEP cases, that was not a problem. That was not the issue. They always, like Daimler versus Nokia, which actually is about a different issue, they took a patent where you know, well, this patent must be valid. You see that, you get the impression already if you see the claims, because you can't almost read them.
It is true that from a business perspective, it's hard to argue against essentiality, because then you end up outside the SEP space. And
but you have to also, of course, if you only get an injunction if the infringement is proven, and the infringement usually proven by using the standard, and that includes the proof of essentiality for the one patent that the claim is based on.
Okay, let's take a look at a question that has also been a source of debate. Is a court the right place to be hearing FRAND disputes and SEP disputes?
Well, I refer to my keynote, I think.
I think Kathy has strong feelings on that.
Yeah, patent cases, so, for those of you who have litigated in a district court here in the United States, you know that we're judges of general jurisdiction. We have huge dockets that cover all kinds of things, including both civil and criminal case matters. And patent cases are extremely difficult. The law is difficult, the technology is difficult, the damages are difficult, and now you're going to layer on the whole worldwide FRAND thing, and it's just, a lot of judges are just going to go, ugh, I don't want to do that. And I would like to see, although I'm a little disheartened by what I heard today, that it's not been embraced, is if you're going to sign on to do this, then part of the contract should be you're going to go to some arbitration panel that's going to get, where they have the dedication of the knowledge, the resources, and the time to figure all of this stuff out. We can send matters out to special masters and experts, and I've never done that in a case because I want to do it myself. But that would be an area where I'd be like, you know what, all of this analysis of the whole portfolio, the whole global aspect, I do not really have the time to give that the proper attention it needs. I want the parties to pick somebody that they could jointly agree would make a recommendation to me. We do all the rest of the hearing, but if I'm going to have to decide it, I'm going to need a lot of help with this. This is not in my wheelhouse. And the idea of putting all this in front of a jury at the end of the day is really scary. I mean, they're just, in a regular patent case, I don't know how a jury could legitimately sit there and distinguish the key factor of where you say you have to value the invention as to what the invention covers in the product, what it adds, and you cannot consider the fact that it is part of the standard. Because I just can't imagine a jury sitting there going, well, but you couldn't make it or you couldn't sell it if it wasn't part of the standard, so that's got to bring value to it. It would just, I don't know how they would be able to dice that out. So do I think we're the right? No, we're not the right. I mean, we do it because we have to, and we will, and we'll do our best at it. But I think in terms of getting, if it's going to be global, it should be global, and everyone should agree. That's rather optimistic and naive, but, you know.
Patents are a national institution, and you're asking to graft onto that a system that is more international in its scope. The wave of academic literature that's out there coming from the academy says it's either arbitration or mediation. There are a couple of calls for supranational forums where these issues would be determined. This is my personal opinion and not legally found anywhere. I don't see any movement to accomplish that. Yeah. I applaud WIPO for trying to set this up. If you saw the Japanese presentation, it's the direction that they're moving in. But you have such a strong national connection to your patent system. And the idea that you're going to abandon that, given this current political state in the world, I just don't see that happening in my lifetime, which may be fairly short.
Well, let's assume the parties won't go to arbitration. They end up in your courtroom. Do you have tips for the litigants as to how they might help the judge preserve court resources, perhaps use of a neutral?
Go to Delaware?
Or Texas.
You know, we had one case that came up to the Court of Appeals when I was there, maybe 10 years ago, and it was Huawei sued Samsung in the U.S. and asked the district court in the U.S. to enjoin Huawei from pursuing an action in China, and the district court did. And so then it came up to us, and the question was, do we, support that injunction or do we not? And one of the things that was most shocking is that you read the briefs, and one of the arguments was that you can't not support that. We want you to enjoin and continue to enjoin the action in China because no judge in China or the United States could ever possibly set a FRAND rate. And their argument was that it should have to go to someplace other than the court system because it's such a business determination, and there's no way that a judge could ever get into the heads of the business people that were involved and how this kind of analysis has to occur. And so I said, well, you've got a problem. And that is, I'm looking at this, and during the argument, I said, you have a problem because you are in the court system. I mean, yes, that's practical, but then why aren't you arbitrating it? Mm-hmm. The case settled, and so we don't actually have a data point from the Federal Circuit with respect to those kinds of issues. But I did think it was funny. It was like, yeah, we're in court. We're asking judges to act, but they're not capable of it, was essentially what they were arguing. Mm-hmm. And I think they have somewhat of a point, but that's why with an arbitrator with some kind of background that would allow them to do this analysis, it might be a much better solution.
I also comment that, there's this sort of antitrust boogeyman that's out there. Logically, it makes sense to me to have the standard-setting organization have a greater role in setting some of these or determining some of these questions. And I know that the standard-setting organizations have just fled the room every time that's mentioned. I'm cautioned not to use sports analogies, but if baseball can get an antitrust exception, it seems to me it makes more sense to get one for standard essential patents.
Well, we thought we did after the Ninth Circuit case, but that was under the last administration, and now they're shifting back the other way, unfortunately.
And it is interesting how they procedurally come to court because it can be initiated as a debt relief action to enforce the contract as the third-party beneficiary, saying that the licensor is not negotiating a rate in good faith, and we want the court to decide it. And then inevitably, I think if it comes in that format, which would it's contract then, maybe, I'm not sure. You've got a diversity, so you're in federal court, you got jurisdiction, but the licensor is going to counterclaim for infringement, and then you're going to get the invalidity claim coming back. So now you're in on federal question jurisdiction, and from a practical point of view, while sometimes looking at damages first in any patent case to say, can we just figure out what most of you all want to do is just get on with your business and get a license set up here. Should we do that first and not go through the whole infringement and invalidity analysis? On the other hand, I don't want to spend all that time trying to figure out some global FRAND rate and then have one of the parties go, I don't like that number, so now I want to challenge whether I infringe or whether this patent's valid. It's like, well, let's do that first then, because if you're not even infringing it, then why should we do the damages end of the case first? And when I did do that, they settled. So, that works.
Well, in Germany, Judge Hoffmann, there's two different stages bifurcated between infringement and validity. Kind of building on what Judge Bencivengo said, do you find that to be helpful or difficult in SEP cases?
I don't think that SEP cases are different than other SEP cases in that question. The bifurcation in Germany has historical reasons because in the 1950s, with the new constitution, there was a constitutional need to have a new to have a court that decides on the validity, which has been done by the patent office before that. And the decision was, well, we want to have a new court because we want to have technically trained judges on the bench. So now we have the Federal Patent Court, which decides with 3 technically trained judges and only 2 traditionally trained judges on such cases. And then we have the appeal at the Bundesgerichtshof. That's the reason for that, and the advantage is that you can do the infringement without the analysis of the validity, and it seems to be justified because the validity has already been tested by the patent office. So that's the idea of it. This seems to change a little bit because the question of validity has become more and more the very relevant question in the cases, and therefore it happens very much more often that the case is set aside by the infringement court to wait for the judgment in the validity trial. I can't say whether there will be a change because, I mean, we have some problems in the cases where you have the preliminary injunctions, because that's very difficult to make an analysis on the validity. Maybe it changes, I don't know. Maybe it changes because we have the new unified patent court where we don't have a bifurcation. Maybe there will be more decisions to set the infringement case aside, so we have not an injunctions before the validity case is decided. Right now there's some discussion going on about that, and I can't tell you what the result will be.
I've often debated this with my many judge friends in Germany because we have this belief in the United States that you can't infringe an invalid patent. That even though you could make a finding of infringement, you can't be responsible for infringing an invalid patent. And what used to drive me crazy was, especially when there was such a long tail on the validity determination, you would put somebody out of business, essentially, with this injunction, and by the time they found out that, oh, by the way, it's okay, because the patent's invalid, that they had to retool and move on to something else. And so very often, you effectively had a complete victory for someone who was actually just practicing an invalid patent. And I know there have been efforts to try to sort of look at the question to see if there might be a serious question of validity, sort of like we would do at a preliminary injunction phase, and then maybe delay the start of the injunction. But it still very much is that impact. And I do think that that's one of the things that's going to come out of the UPC, is that with all the people that were involved in determining how it was going to operate, there was a real belief, especially with those from the UK who were involved at the time, that the two decisions should be made at the same time.
It's an interesting. I was just sitting here thinking about it, because now that we have the AIA, and so almost in every case somebody moves to stay so that they can take their invalidity challenge back to the patent office, and then we sit on the rest of the case. But in a case where you have an SEP and maybe established rates with other groups, you could, while the invalidity is going on with the IPR, work on the FRAND rate, and it might be something that is more easily done in parallel than you normally do, where you end up with things that end up in conflict. I haven't had that happen, but I suppose that would be a partial stay that might be worth following up on in the context of a FRAND, as opposed to where you don't even know if you infringe yet.
Well, let's just let me add something, because if the proponents of the bifurcation system would say patent law is about competition, and competition, or to restrain competition, actually, to prohibit competition, and competition is a matter of time. So they would say, if, for instance, if a pharmaceutical firm that has come to a medicine that is very expensive, and somebody just copies it for less price, then the pharmaceutical firm would be out of business with its own product, because it can't produce, it can't distribute the product for this low price, and on the same time get a revenue for the R&D costs. On the other hand, we have had a case where a US firm had a patent and sued somebody in Germany, and they got an injunction, and at the end the patent has been found invalid, and the person of the company that had to stop the production came up with a quote in an article that said, "The German patent system is ill."
Well,
she didn't really like it, and they said she had damages of 20 million euros because of stopping the production.
Yeah.
And the point maybe a little bit is that if you got an injunction, you are definitely out of business, and you have damages just because you are out of business. You can't get on with the contacts with your clients.
Well, I think that, in the pharmaceutical space, that's a classic case in which either you're in the ANDA or biosimilars space where the party who is intentionally copying and affirmatively copying is not allowed to actually get approval to market the drug until the determinations of validity and infringement have been made. And then outside that space, that would be an easy case in which a preliminary injunction would likely issue. One of the irreparable harms is that you can't recapture the market. And
Yeah.
so that would probably be a pretty simple case for a preliminary injunction. It's just that there would be more analysis of the likelihood of success.
Yeah.
Maybe just want you said patent law is about competition, and I think patent law is about innovation. The point to giving people's patents is the contract with the government that says you have shared your invention with us, and we are giving you the right to exclude in the corresponding reward, the compensation for that. And that's why I think eBay, I have to follow it, it's Supreme Court precedent, but I think they missed the point in irreparable harm. The patent holder has his thumb on the scale. You got a patent and you proved it was infringed and it's valid. You have under the statute, you have the right to exclude. And you can't be forced to compulsorily license people who just want to practice your patent. The FRAND commitment and SEPs raise that thumb off the scale a little because you've now entered into a subsequent contract with other people to say, okay, you're going to use this and everyone's going to have to use my technology. I will make a commitment, therefore, to give you the right to enter a license at a fair, reasonable, and non-discriminatory rate. So when you measure the irreparable harms there, I think that the right that the patent holder had to just say, no, I'm not going to license you. And I don't know why the Supreme Court just wrote that out of eBay. It is going to be reweighted. And yeah, maybe a little harder, but that also doesn't give somebody the right to just practice something without paying for it. This is an economic exchange, and you diminish innovation if you just say, yeah, no, it became the standard, and now you just got to let everybody play on their terms. Then why would people want to share their innovations?
Let me get back to something Judge Hoffmann said about bifurcation. In Sisvel v. Heyer, Sisvel was looked at as not being a willing licensee because it caveated its willingness to take an offer. It caveated it based on, proof of infringement and proof of validity. That they became an unwilling licensee because of that. How can that possibly be? I mean, how could somebody pay money without knowing whether a patent is valid and infringed?
Well, I don't consider the judgment in the way that you have to pay the licenses and the license fees and are not able to get it back if the patent will be found invalid. Mm-hmm. So that's a little bit different from typical licenses. We know, at least in German law, you don't get the patent fee, you don't get a return on your patent fees if the patents are found invalid afterwards. I would not consider this judgment in the way that the license that would be concluded as a result of the litigations would have this condition as well. Although it's not very clearly, so I can't tell you that. But otherwise, you would have a problem with a statement in Huawei versus CTE that says, of course, the implementer is right to challenge the validity. The point was that the offer of the implementer was made under this condition to say, well, if, and the point is, if you have such conditions, you cannot conclude a contract, and that's what this process shall be about, to get an agreement on a license. And if you have several caveats to that, you do not have an agreement, and the infringement continues.
Yeah, you remember, if you drill down on these cases, in almost all cases, the implementer has A, chosen to practice the standard, and B, has advertised the value of its goods because they comply with the standard. And that gets lost sometimes in this discussion, and I think it's important to remember that. Yeah.
And one thing, the problem is that the situations where the negotiations, the time where the negotiations took place in civil facades was, I think, 215 or something like that. And nobody really knew at that time what the judgments of the Federal Court of Justice would be afterwards. And I think now you know what the judgment is, and the people know how to react to that. I don't think that this will be a problem in the future.
Let's talk a little bit about disclosures. One of the complaints or disagreements that were given to the UK's IPO was transparency and disclosures. In the US, we have the patent local rules, which requires an interchange of information. And we saw a little bit about the Huawei choreography, if you will, concerning disclosures, but it was very vague in terms of what was required. So the US has the more specific, I would say, post-suit disclosure requirements, whereas Germany seems, and I'd like to kind of open this up to the panel, seems to require less. What are your thoughts on that disclosure process?
Disclosure in terms of when you're agreeing to be part of the standard?
Yes.
Yeah, because when you see it, sometimes in an infringement contention, and the person who's alleging that their patent is covered is standard essential, and then basically the infringement contentions are the marketing materials of the accused infringer that just says, well, it meets the standard, i.e., therefore it's covered by my patent. And that's a pretty big jump sometimes, most of the time. And they do, and in part, it's my understanding, people do that because they don't have to necessarily declare in what context their invention, their patent, is essential and part of the standard, and it's necessity to practicing the standard. And yeah, it would be hugely helpful if that was a requirement, but I also don't know how practical that is, because the standards can be broad and the patents can be significant or insignificant. You may not even have been part of the standard setting organization, and you later find out something you were doing is essential to the practice of that standard. So, you know, in a perfect world, I think if you're going to do this bargain that says you're going to adopt my technology as part of a standard and I'm then going to offer reasonable licensing rates, yeah, it would be nice if it was, you know, and here is A and B and C and it all, but that's not going to happen, I don't think.
As the earlier panel pointed out, the danger is if you don't identify something as essential and it turns out to be, and you've got a patent that covers it, you no longer are allowed to enforce it through the SEP framework. So it's dangerous, and so the incentive is to throw it all in there, which happens in a lot of contexts, but there has to be a better mechanism. This is why I always go back to the standard setting organizations, is I don't understand how they can say, okay, we're going to have this vague agreement that says you'll do something. We're not going to say what the parameters of that are. We're not going to say what the mechanism for resolving it is, and we're going to call it a contract.
Yeah.
You know, I mean, in basic contract law, you're missing material terms here, and I just think it would make a lot more sense if the standard setting organization had some mechanism for defining essentiality and some arbitral mechanism for resolving disputes. I just don't know why they're not willing to engage.
Well, I'm actually not quite sure why it's such a problem, but maybe it's because in Germany we didn't have such cases that have had this problem, because we always say, well, the implementer is not really interested in getting a license, which in these cases might really have been the case. Actually, I think it's a matter of practicability, not really a matter of disclosure, because everything is open. The patents, you can read all the patents, you can read all the standards, and the question is who's doing the research.
Yeah.
which is, I know, hard work. and and but that was in German cases that was not really the real issue.
I mean, I think one of the issues that came out of I keep calling it a report, but I know I'm not supposed to call it a report, but of the study in Europe was that it's not very transparent as to how the standard is chosen, or which parties' patents or technology is chosen to be the standard,
Yeah.
and it's not very transparent as to how someone decides what patent is covered by that standard. And so I think that's one of the complaints, is there needs to be a greater ability, short of having to do an analysis of every one of those thousands of patents that often show up in the standard. It's short of having to do that full-blown analysis. How can we know, like a new implementer, know that they can be confident in practicing the standard? How can someone whose technology they're offering up to be part of the standard, how can they know that there's going to be a mechanism for them to enforce all their rights under the standard? So I think it's difficult for both sides, and that part of the study, I think, is probably something that is difficult to address, but is well taken.
Just a little off topic, but just made me think about the transparency here. And an earlier panel talked about taking these matters as contract matters to state court. Boy, if you really want to create a lot of turmoil, it's bad enough if they're going to the regional circuits instead of the federal circuit. Who you tell them, well, you had to look at the Georgia Pacific factors, and they'll just give you a blank stare. A state court judge is going to just be just hamstrung by all the stuff that has to go on here.
Well, on the point of transparency, should there be less reliance on non-disclosure agreements? And do you think maybe the parties should be less protective of the information, given this is a FRAND case and given there's a FRAND commitment?
I'm going to repeat something that was said this morning. The crown jewels is always your licensing rates. Mm-hmm. And companies in a capitalistic system are not obligated to charge everyone the same. Mm-hmm. And as a result, they are not going to give that material up outside of compulsory disclosure through a protective order where it is very narrowly distributed. So I'm not sure how you accomplish that unless you're just going to rewrite the entire area and say, yes, this is now required in order for you to belong to a standard. And I think the result of that will be that the standards will decline.
And that's especially true when you've got a situation where, it depends on what you're licensing. Are you licensing, what you get in return? Are there cross licenses you're getting in return? Are you only licensing, one patent to this party, but a whole bunch of patents to someone else? So that's the problem, is you disclose that, and from a business perspective, what's going to throw in your face, which is, well, that is the exact number you have to give everybody else, and not everybody's equal.
Well, I think in the expert group of the European Commissions, we have a proposal where we say you could have a confidential repository for notifications about the relevant factors of a license agreement. There is such a similar rule, I think it's European-wide or something for the electricity market, where you have to notify about agreements on electricity, and the notification is confidential, and but the board that is taking the repository that is receiving these notifications, they publish a report that says how the market is generally developed, and I think that is a good idea. Until now, I really don't know why license agreements are really that specific that there would be so much harm if somebody leaks the content. But everybody says that it's impossible to let it go public, and I have to assume that there must be some reason. But
It's just needing to make sure you're comparing apples to apples.
Right.
yeah.
Kind of going back to the question of advocacy, one of the issues I have when looking at the Motorola case, the decision, 200 pages of damages analysis, and by the way, it's not a problem with your decision, but the amount of work that it took to get through that, the amount of understanding on economic principles was mind-boggling. So the question becomes, were there ways advocates could have made it easier for you, or is it inherently a 200-page decision?
You could make it easier for me, but it would require you to abdicate your advocacy role. You're getting a presentation from one side that is portraying a desert, and you're getting a presentation from the other side that is portraying a jungle. And neither is going to move off of their analysis of that situation. And as long as we're going to engage in this advocacy as opposed to a regulatory format, I don't know how you make it easier. I will tell you that, we have a 30-day rule in my chambers that motions are right for 30 days and they should be decided. We at the height of the Microsoft versus Motorola case were dealing with 7 months because we just didn't have the resources to do otherwise. And I don't expect a lot of sympathy from the audience because when you impose a rule that you may not file any further motions without telling the court first and getting permission, you're not popular, but sometimes it's just necessary.
It always feels like the first two letters there, the F and the R, disappear when the damages experts get in the room, and what's fair and reasonable are orders of magnitude apart. And it's like, if you're both reasonably applying the same economic principles here, why are the opinions so disparate? And in your case, like you said, the jungle and the desert, I mean, it doesn't help us at all. And it doesn't help you to have me come up with my own theory at the end of the day.
As they found out.
Is there a loss of credibility in terms of the parties coming in so far apart when it's supposed to be a fair and reasonable determination, or is it just something that the court unfortunately has to grapple with?
Well, reasonable royalty is essentially also has that R in there.
Yeah.
And parties are always very far apart in their assessment of what's a reasonable royalty. I think it's just kind of the nature of the beast for patent litigation. But that's why there's got to be a better tool.
I mean, it's the nature of the beast of advocacy. When I sentence people, the government is at, 10 years and the defendant's at time served. So you get the same, whatever, people come in with their point of view.
Judge O'Malley, this is a question that, first of all, White Bauz has been very, very helpful and supportive of this conference, and we thank them very much. I do want to ask about the Judicial Advisory Board of White Bauz, and you're the only U.S. representative on that board, and wanted to know a little bit about what they do.
Yeah, that's a little bit of a segue here, but that board is not there to provide advice for things like how best to handle SEP cases. I mean, it's a topic that's been raised and that we should discuss. But right now, we're still pretty basic. We're trying to bring along judiciary from all over the world and give them best practices on managing litigation, period, any kind of patent litigation or IP litigation. And so we're still at such a basic step. You know, you need to have a case management conference. You need to, to construe the claims. You need to, so there's still a lot of that work that's being done. But the hope is that this will build into something where we will globally, among the judiciary, talk about best practices that go all the way to things like SEP practices. But they right now, because the other portion of WIPO is working on SEP, there is coordination, but it's mostly being left into the hands of those who who believe that arbitration or mediation are the best mechanisms.
We're running out of time. I'd like to thank the panelists, all of whom traveled to be here today. Greatly appreciative of your time and sharing this information with us. Once again, a reminder about the Chatham House rule, and thank you, panelists.
Thank you, Thane. And thanks for inviting me.
Before we close the 2022 Global FRAND and SEP Symposium, I just want to acknowledge some people who helped make this possible for all of us. I can't read all the names, but you'll recognize the faces. It's been wonderful to see old friends and meet new friends. Another acknowledgement is to our platinum sponsor, McCool Smith, who, like all our sponsors, helped to make this event possible. I'd like to thank Cater 2, our caterer, and FN Tech, who did a wonderful job producing this event. Thank you to all of them. And of course, thank you to the Executive Director of Bauz IP Law, who put in an enormous amount of time to make this such a fabulous event. Thank you, Maria, for your help. And now the Computer History Museum has done a wonderful job as well, and they're leaving 25,000 square feet of their museum open for us during the networking reception. So thank you to the Computer History Museum as well, and we look forward to seeing you downstairs where there will be not so small plates to enjoy. And thank you for those remote participants as well who joined us from 3 continents, as well as our speakers and moderators who also joined us from 3 continents. Thank you very much. Enjoy.